Mr. Brickhill?
Chairperson, Madam Commissioner.
Oh,
Mr. Semenya was on his feet. I apologize. I should be seated.
No problem, Mr. Brickhill. Chair, of course, today we're sitting to hear the oral submissions by the various representatives of people affected and interested in this commission. And as you would have indicated, Chair, we will have the submissions from Mr. Brickhill to commence with. And the sequence you have indicated to us in chambers, with us as evidence leaders making our submissions last in response. and this is the purpose of today, Chair.
Yes, there is no reason for the interpretation of the submissions to be made.
I would appreciate that comment, Chair, because in real terms, this is argument as opposed to evidence.
Yes. Thank you very much.
Yes, ma'am.
Chairperson, I'm indebted to my learned friend. Good morning, Chairperson, Commissioner Mabena. Chairperson, at the outset, we have taken heed of your directive indicating that there would be oral argument to try to focus on the differences between the parties.
Yes.
And in an endeavor to do so, Chairperson, we have prepared a short note for argument. It's in the form of a table. It's not new material or new authorities. What it does is to take the positions of the parties and indicate where the parties are on the same page or where they differ. Chairperson, Commissioner, we've provided a copy of this table to all of our learned friends, and I understand that copies have been provided to you. It's the short bound document headed SERI ICF note on the parties' submissions on findings and recommendations.
I don't have such a copy.
Chairperson, I think it's underneath the Norton Rose file closer to me.
Oh. Thank you.
And I apologize that it wasn't provided earlier, but it was really a note in preparation for argument. And as I indicate, there's nothing new in it in terms of authorities or materials, just a synthesis.
That is understandable.
Chairperson, I will come to the table and the parties' submissions in due course, but we have 5 issues to address at the outset by way of preliminary foundational submissions that cut across the other issues. And those 5 issues relate, Chairperson, Commissioner, to the scope of Part 1 of the proceedings, the question of liability and responsibility, the meaning of those terms in the terms of reference. Thirdly, the threshold for making findings and questions of standard of proof. Now, those 3 issues are all addressed in our heads of argument, but we'll just highlight the essence of the submissions. And then the 4th issue that we need to address is the question of rights to services. And the final issue is a question of law, and it's the question of a right to alternative accommodation in the circumstances of the residents. Chairperson, just for purposes of timekeeping, it's 10:15 now. I understand that I have an hour. I think I started at about 10:10.
Yes, so you already have your 5 minutes.
Thank you, Chairperson. Okay, so let me move then straight to the first issue, and that is the question of the scope. This Commission of Inquiry is somewhat unusual, although not unique, in conducting its proceedings under the terms of reference in 2 phases. We've agreed, I think, that the correct language looking at the terms of reference is Part 1 and Part 2. because the terms of reference divide under those two paragraphs. And it's crucial that we understand at this stage, at the closure of Part 1, what properly falls within Part 1 and what is outside it. And we really have two submissions to make in that regard. The first relates to what we think are an important set of issues that do fall within Part 1. And the second relates to issues that we say fall outside and properly belong to Part 2. In essence, Chairperson, Commissioner, it's our submission that Part 1 has its central focus on the building, on the events at the building, the residents, and the events that surround the incident of the fire. Whereas Part 2 is concerned with broader systemic issues and with other buildings in the inner city. That's the essence of our understanding of the division. And the process, of course, is that at this stage, Part 1 has come to a conclusion, and the Commission will issue its report. It's not our understanding that that report is provisional in nature. It's our understanding that it is a final report on Part 1, having regard to the terms of reference. And therefore, the Commission will be making final findings and recommendations in relation to Part 1. The difficulty that we have all, I think, grappled with is the overlap. And we accept that some of the evidence that has been led so far certainly relates to broader systemic issues, in particular evidence of the mayor and other officials of the city that goes to broader policy questions, other buildings. We submit that that was appropriate. It has enabled the Commission to contextualize Part 1 and to also make significant progress in receiving the evidence relevant to Part 2. But if I can begin with an important submission on an issue or set of issues that we say do fall within Part 1 and haven't received particular attention in argument from the evidence leaders or the city. And Chairperson, those are the events effectively from the fire onwards that left the residents homeless. And we submit that those issues fall within Part 1 because of the inclusion in the terms of reference of the word homelessness. The full phrase is circumstances leading to homelessness, in addition to the deaths and injuries. And we submit that having included that term, the terms of reference therefore include the fact that the residents were left homeless by the fire, the facts that they were placed in certain shelters, and the events relating to the provision of alternative accommodation to them. Chairperson, we submit that it would be unbalanced were the Commission, for example, to look into what is to happen to the building after the fire, should it be demolished, one of the issues that is being debated, and what is to happen to officials, to hold them accountable, and so on, but not to look at what has happened to the residents and what is to happen to them. And so we submit that that set of issues properly falls within Part 1. What has happened to the residents, as a matter of fact, since the fire, and what needs to be done now, if anything, in relation to their situation. I should emphasize that we accept the limits of the Commission's power in that regard, and certainly that the Commission didn't have the power, for example, to interdict their removal from shelters, or to order the release from Lindela of certain residents who were detained. We accept that that would have been outside the Commission's powers. But it's a different matter whether the Commission should look or turn a blind eye to what has happened to the residents since the fire. And we submit that properly interpreted, the terms of reference include those events. So that then, Chairperson, Commissioner, is our first submission on what is in. We have a second important submission with respect in relation to what should properly be kept out at this Part 1 stage. And in essence, Chairperson, Commissioner, it is the issues that fall within Part 2. And we submit that there is some risk of findings being made, perhaps inadvertently, in relation to Part 2 issues at this stage, and that care needs to be taken to draw that line. And this is important, Chairperson, for a range of reasons. First of all, it's how the terms of reference set out the Commission's powers. So there's just a question of powers. But there are also questions of evidence and prejudice. There has been evidence led, for example, close to the end, for example, the testimony of the mayor. Those issues broadly relate to Part 2. Those witnesses there hasn't been opportunity to cross-examine them. SERI and ICF, for our part, have reserved our right to bring applications to cross-examine those late witnesses. And so we submit that care needs to be taken not to make definitive findings at this stage on that body of evidence. The further submission, Chairperson, is that the essence of Part 2 is the systemic issues. We, as SERI and ICF, intend to lead our evidence because our interest is primarily in relation to Part 2 at the commencement of Part 2 and are engaging with the evidence leaders in that regard. And Chairperson, those systemic issues they're difficult issues of fact and law relating to the city's policies, questions of provinces' powers and policies, and questions of the state of other buildings. And for example, there is some discussion at present about inspections of other buildings. And so, Chairperson, the core submission is that while the Part 1 findings may require the situation of the fire, Usindiso building, and the residents to be contextualized, care should be taken at this stage not to make findings or recommendations that go to the systemic issues. Chairperson, that then is my first preliminary submission, which goes to the scope of the inquiry. Chairperson, I should indicate when I deal with specific issues, I will indicate, for example, our response to certain arguments of the evidence leaders, that while in principle we may agree with them on certain issues, we will argue that they are Part 2 issues and that no finding should be made at this stage. And I'll indicate that when we get there. But I've made the in-principle submission about drawing that bright line. The second preliminary issue, Chairperson, Commissioner Mabena, relates to liability and responsibility, those key terms in the terms of reference. And we've prepared argument on these issues, Chairperson, my learned friend, Mr. Tobachale, and the SERI team and I. And we've indicated that the terms need to be distinguished. Both terms are used in the terms of reference. And we've argued how in our submission they ought to be understood. In essence, we say that liability is concerned with civil or criminal liability. That's the essence of it. And the civil liability in these circumstances is likely to be delictual or contractual. But in essence, that is how we understand liability. Responsibility, we submit, goes broader. And it will arise even where there isn't potential criminal or civil liability. It has a moral connotation, but in the terms of reference, we submit that it needs to be given a legal meaning. And we submit that responsibility would arise, for example, where there has been breach of a bylaw or failure to discharge a particular legal obligation that does not rise to the level of creating criminal or civil liability, but is nevertheless unlawful in some way. And that is, in our submission, how the two terms might be understood. In practical terms, liability will, of course, finally be determined by a court. Criminal liability in criminal proceedings and civil liability if any civil claims are brought. But the Commission, we submit, is empowered to make findings that on the evidence before it and having regard to the law, there is a basis to conclude that certain parties may be liable when those proceedings in court ensue. In relation to responsibility, the Commission is empowered, we submit, to make those findings of responsibility. I'll come in a moment to the finality and the issue of prima facie and so on. But in relation to liability and responsibility, there's one more important issue that we need to address. In the recommendations and the findings, there are arguments targeting or focusing on either individuals or institutions, or both. And we submit, Chairperson, Commissioner, that the appropriate approach is to look at both and that it will be appropriate in due course, if the factual material supports it, to make recommendations that relate to liability and responsibility of both individuals and institutions, including individual officials. And we've made certain submissions in that regard. Chairperson, if I might then move to our third preliminary submission, and that's the question of threshold for factual findings, standard of proof, and so on. And we've made detailed submissions on this on our heads. There are certain key points. The first is that in a commission of inquiry of this sort, there is no onus of proof. There's no technical onus, and no strict standard of proof to be applied, neither reasonable doubt nor balance of probabilities. And we've drawn, Chairperson, on a range of other commissions of inquiry, dating most recently from commissions like the Khayelitsha Commission and the Marikana Commission, Chairperson, the commission that you yourself chaired into the Scorpions, back to the Goldstone Commission and earlier commissions. And we submit that those commissions establish a fairly common approach to this set of issues around threshold, standard of proof, and so on. So those are the first 2 points. No onus, no strict standard of proof. It is so that the Marikana Commission treated balance of probabilities as a useful starting point, but the Commission in that inquiry emphasized that in any event, balance of probabilities is a flexible standard. And when it came to making recommendations, the Commission didn't require that there be proof on a balance of probabilities. They were willing to move on the basis that there was a prima facie case sufficient to make a recommendation. And Chairperson, that's our third point on this issue, which is that a prima facie case where there is sufficient evidence to make certain findings is an appropriate basis for this Commission to make recommendations, for example, towards further investigation that may lead to prosecution, towards disciplinary proceedings, matters of that sort. It's not necessary for this Commission to satisfy itself as a matter of absolute finality, applying the strict standard of balance of probabilities before recommendations follow. And we submit that approach, it's not only consistent with all of those previous commissions, Chairperson, Commissioner, but it's also appropriate institutionally. Because if one looks at the sort of recommendations that are being debated, there are recommendations towards further investigation, whether it's towards criminal or disciplinary proceedings. And it's in the course of that investigation that finality will ultimately be achieved in the end through a court determination or through a disciplinary proceeding. And so those are our submissions on threshold, and it's on that basis that we have approached the issues. It's our submission that our approach is broadly consistent with that of the other parties. They may not have addressed each of these issues necessarily expressly, but as we read their submissions, we take it that certainly in relation to the evidence leaders, a similar approach to these sorts of questions has been taken. Chairperson, if I might then move to our fourth preliminary submission. And this relates to the question of right to services. And I want to deal with it up front and at a principled level. I'll deal with it in relation to some specifics when I come to the arguments. And Chairperson, we submit that it's a central dimension of the inquiry that requires significant attention. It's really the Bill of Rights dimension. Chairperson, there's much in the evidence leaders' submissions regarding compliance with bylaws and compliance with the law with which we agree, and I'll indicate the extent of that agreement. But we submit that there's a separate parallel legal framework here that is also live, in operation, engaged. And those are the rights of the residents. And they include, crucially, the right to housing, the right to water, and the right to electricity, the right to sanitation, and the right to refuse removal. Most of those rights fall under the rights to basic services, which are captured in Section 152 of the Constitution and were recognized by the Constitutional Court in the Joseph decision as giving rise to a public law duty to realize the right to basic services. The right to water, of course, is separately recognized in the Constitution and has been addressed in particular in the Mazibuko decision. And Chairperson, we've made the submissions, and the residents have advanced similar arguments that these rights of the residents were limited, were violated by the conditions in which they lived prior to the fire. So that's the central part that I'm focused on now. There's a separate argument which relates to their treatment subsequently and the alternative accommodation. I'll deal with that separately as the next issue. I'm currently concerned with their rights living in those conditions in the building. And we make the submission, Chairperson, Commissioner, that the facts establish overwhelmingly that the conditions in which they lived fell short of those constitutional rights. The housing was overcrowded, unsafe, as was overwhelmingly emphasized by what happened, and generally fell short of the standard of adequate housing. They had inadequate access to water. They were accessing water through equipment that was meant for firefighting. In terms of electricity, the electricity supply was intermittent and was, in the later stages, secured through an illegal connection. And in relation to refuse removal, there has been substantial evidence that the building was at times strewn with refuse, and we endorse the evidence leader's submissions in relation to pick it up and its obligations. But for the present, the submission that we're making is that each of those rights of the residents was limited, was infringed in those conditions. Responsibility for that is a separate question. But we submit that that recognition of their rights is significant and needs to be made up front so that the matter is not framed exclusively as a matter of compliance with bylaws. There's a separate crucial dimension which runs parallel to the bylaws and which really asks us to see the events, see the conditions from the perspective of the residents and in due course from residents of other buildings, not simply from the perspective of bylaw compliance, building standards, fire safety standards, and so on. Crucially important, and we endorse most of that, but separate. And Chairperson, in this regard, the city has advanced two arguments why there were no breaches, effectively, of rights in the situation prior to the fire. The first is a limited resources argument, and the second is an illegal connection argument. Chairperson, we submit that limited resources argument has not been adequately substantiated in these proceedings. The courts in a line of cases, in particular Blue Moonlight, but other decisions, have held that where the state relies on limited resources to justify the failure to realize socioeconomic rights, it must fully substantiate those limitations. And we're here concerned just with the single building and the limited number of residents in that building. Crucially, Chairperson, Commissioner, the city concedes in its written submission, as it must, that these residents would likely have qualified under the city's ESP, Expanded Social Package Policy. That policy provides for free, and for now let me deal with free basic electricity, water, and a remission in relation to refuse removal. And Chairperson, the city's argument effectively is that the building was hijacked. It's a central theme of their submissions. The building was hijacked, it was unsafe, and so we couldn't provide those services. Chairperson, there's been evidence of the engagement of JPC in particular with the building, and then the blitz, the raid, the 2019 visit. What was clear, abundantly so, is the city and its entities, all of them, were very aware of the conditions in the building and had been so aware for a significant period of time. we submit that the appropriate approach, what was required of the city, was not a predominantly policing approach looking to arrest people, but it ought to have focused on the provision of those services. And had it done so in relation to water and electricity in particular, the conditions in the building and the risk that they presented would have been mitigated, at least to some extent. Had there been proper water provision throughout the building, had there been electricity properly throughout the building, it would have made the building a safer place, would have made evacuation safer, would have made firefighting easier. Independently, it is though it's independent of safety, it's a violation of those rights. So, Chairperson, we submit that with respect, the Commission is enjoined to look at the rights dimension of what happened here, and not simply the bylaws violations dimension. They need to be understood together. The purpose of the bylaws, in large part, is to protect the rights of people living in buildings. It's not to protect the rights of buildings. Chairperson, I'll return again to some of the detail in relation to rights, but that is our submission in relation to those rights. My final preliminary submission relates to the question of alternative accommodation, which is really a subsection. It's a sub-issue, but it's a crucial one of that question of rights. As we understand the evidence leaders' submissions, they are that there was no, upon the incident of the fire, when that happened, and the residents were left, many of them on the street, there was no obligation at that point, in terms of our existing jurisprudence, on the city to provide alternative accommodation, temporary alternative accommodation to them. As we understand the argument, it is that the jurisprudence has centered around the incident of evictions, cases like Blue Moonlight, and doesn't apply in circumstances such as this fire. And Chairperson, for their part, the residents appear partly to concede this, and we submit wrongly so. They say, well, there may not have been an obligation to provide alternative accommodation, but the city did so. And they then focus their argument on the conditions of that alternative accommodation, the 3 shelters and ultimately the shacks at Denver. And they say that those conditions violate their rights. But we're focused on that first key question, Chairperson. Was there a right to alternative accommodation? And Chairperson, it is also a key question for Part 2, because it will, in confronting the question of what can be done about buildings that face similar challenges, a central issue is, if people are to be removed from unsafe buildings, is there an obligation to provide them with alternative accommodation on a temporary basis if they will be left homeless by that action? And Chairperson, we have 2 submissions on this issue. The first is that it is primarily an issue for Part 2. The second submission is that there is such an obligation. And we accept that there may be a need at this stage to make a finding on whether there was an obligation to provide alternative accommodation. There is an alternative approach, which is really the residents' approach, which is don't decide that question at this stage, because alternative accommodation was provided. And so perhaps, arguably, it's not necessary to decide in Part 1. But if it is necessary to decide it, we submit that our law is in fact clear that the obligation to provide alternative accommodation applies not simply in the eviction context, but more broadly in the context of emergencies. And Chairperson, this law has its roots in Grootboom. Grootboom, of course, found the National Housing Program unconstitutional precisely because it failed to provide for people in the most vulnerable and urgent circumstances. On the facts there, part of that situation arose from flooding in Cape Town. Grootboom in turn led to law reform. It led to the adoption of the National Housing Code under the National Housing Act, and specifically the Emergency Housing Program, which operates at national level and is part of the National Housing Code. And in fact, it's that policy, and in fact it has the status of delegated legislation. It's that instrument that provides the basis for provision of alternative accommodation by all municipalities. They may have their own specific policies too, but they operate under the national framework. And Chairperson, under that national framework, the situation is actually reversed. It's not a focus on evictions and also fires and floods. The starting paradigm is an emergency, which is understood to include natural disasters, but it has been defined to include evictions. So emergency under the EHP includes an eviction, and it's on that basis that local government, which has the implementing obligation, is required to provide alternative accommodation to people who will be left homeless, and that's the trigger. And that obligation applies whether it's a flood, a fire, or an eviction, and after Blue Moonlight, it applies whether the building was privately owned or owned by the state. And Chairperson, we refer to one additional authority in this regard, and I can provide the full citation, but it's the Constitutional Court decision in Abahlali Basemjondolo. And that matter, Chairperson, concerned, as you are well aware, Chairperson, a challenge to the KZN Slums Act, provincial legislation, which was passed to provide authorities in KwaZulu-Natal with the power to remove people from buildings defined as slums where there were unsanitary conditions in a parallel law to the PI Act. And Chairperson, the Constitutional Court in Abahlali declared the, Section 16 of the Slums Act unconstitutional, effectively because it didn't contain all of the protections that have been established under Section 26 of the Constitution and the PI Act. Notice, joinder, engagement, and crucially, consideration of availability of alternative accommodation. There were two judgments in the matter. Justice Yaqub effectively tried to interpret those requirements into the Slums Act to save it from unconstitutionality, but the majority in Justice Moseneke's judgment held that it couldn't be so interpreted. That was stretching the language too far, and that it had to be struck down. The point of that case, Chairperson, is that it's not permissible under a parallel framework to bypass Section 26.3's protections and the protections of the PI Act, effectively to remove people on the basis that a building is unsafe or unsanitary, and bypass all of the PI protections, in particular the alternative accommodation aspect. So, Chairperson, we submit that on the basis of those two key authorities, if the Commission does have to reach this issue at this stage, there ought to be a finding that there is a legal obligation in conditions like this.
Yes, but is there a need to reach to decide this issue in light of the fact that alternative accommodation was provided?
Chairperson, with respect, it may not be necessary at this stage. And it is an important issue that may well benefit from full ventilation and argument. The evidence leaders, for example, have addressed the issue in one paragraph of their submissions, and the issue may benefit from further and full argument at Part 2. So that was our primary submission, that it may not be necessary to reach it, but if it is reached, there was an obligation.
Okay.
Chairperson, those then are our five preliminary issues. And the first first four really cut across many of the remaining issues, and the fifth is a discrete legal question. If I may then, in the remainder of my time, turn to our note and the positions of the parties. And I will endeavour, Chairperson, Commissioner, to move through this quite quickly, especially where there's full agreement. Chairperson, as you will see from our note and from my submissions, we agree with a very large proportion of the evidence leaders' submissions, and it's there that I will start. They frame really the issues in this commission, and we've taken their submissions as the starting point, and we've indicated where we support their proposed findings and recommendations, and in many respects we do so fully. In certain respects, we support the recommendation, but suggest an addition or a qualification or a slight reframing. And in a few respects, we do oppose certain of their proposals. Chairperson, if I might then begin with with the evidence leader's submission. And our note follows a similar format, Chairperson. There seems to be some unrest in the venue. But,
Yes.
Chairperson, our note is in this format. It sets out in the left-hand column the submissions, the proposed findings or proposed recommendations of each of the parties, and we deal with the evidence leaders, the city, and the residents, and then set out our own. In the second column, we provide our brief response, responding, Chairperson, to your directive in setting down oral argument to focus on the differences between the parties. So if I might begin with the factual findings, and there's a key set of factual findings that the evidence leaders propose at paragraph 27 of their submissions. And those are set out in the left-hand column. That the building was used for residential purposes in contravention of the zoning bylaws, that it was a haven of crime, that SAPS and JMPD law enforcement responsibilities were virtually absent, that the building did not comply with fire safety requirements in contravention of the bylaws, that the supply of water and electricity to Usindiso was illegal, that the building was overcrowded and that the tenants were estimated to be over 500, that it was a health hazard and nuisance in contravention of the bylaws, and that there is no political or executive accountability by city officials for the condition of Usindiso and the aftermath of the fire. So these are really a core set of factual findings. They're actually a combination. Some of them are factual and legal. And Chairperson, we support all of these findings. We've suggested simply three partial exceptions or qualifications. The first, Chairperson, is concerning the zoning, and it's having regard to the city's submissions in this regard. Chairperson, we find ourselves in a difficult position to form a final view on the zoning, given the city's submissions regarding absent documents and the fact that there was an intention and a decision to shift the zoning, but that the relevant documents don't appear to be located. And in those circumstances, Chairperson, I suppose our submission is to caution some qualification that it's not entirely clear. And that it's not possible to make a final determination whether that change did take place. That's our first qualification. The second relates simply to the haven for crime, and it's a submission that we make in our main heads and in a few other points in this note. But it's just, Chairperson, to take particular care around language that may inadvertently be read to imply that all of the residents were engaged in criminal activity. And we submit, Chairperson, that care should be taken to indicate that there were indeed crimes committed. In fact, the victims of those crimes were typically residents of the building. But to make the point that there may have been criminal actors, criminal elements, but that this didn't relate to all of the occupiers. Chairperson, we also make the point that, and this is addressed in the residents' heads, that there is also the issue of SAP's engagement with the building and evidence that indicates that there were regular visits which appear to have had as their purpose the solicitation of bribes from residents in the building. So we make those additional points in relation to haven for crime. We do accept that there were criminal crimes committed in the building and that it was an issue of concern. The third issue, Chairperson, is the question of supply of water. And Chairperson, it's the issue I've already addressed, that yes, there may have been illegal connections, but there is a separate question of the rights of the residents who qualified, the city concedes, or ought to have qualified to receive free water and free electricity under the city's own policy. So the illegal connection needs to be understood in that context. The next issue, Chairperson, concerns a recommendation that the mayor should consider the position of MMCs and their political responsibility or oversight, and that the accounting officers of the city's entities must be subjected to disciplinary proceedings. We support these proposals by the evidence leaders. And Chairperson, our only qualification there relates to the third point, which is around demolition of the building. And I might as well address that now. The evidence leaders, relying on Mr. Moodley's evidence and other evidence, make the submission, seek a recommendation that the building should at this stage be demolished. We argue, Chairperson, in our heads that the building should not be demolished at this stage for a few crucial reasons. The one is that it remains a crime scene and that there may be crucial evidence, both in relation to potential prosecutions, but also potential civil proceedings by the residents or others. And it would be ill-advised, we submit, to destroy that evidence. Neither the SERI ICF team nor the residents, as I understand it, have been able to conduct an inspection in loco at this stage. So we submit it would be
How
premature.
will they be able to conduct an inspection in loco if the building is not safe?
Chairperson, we accept the concern, and we're not today seeking a directive that we do so. We're simply saying that at this stage, caution should be exercised in giving the go-ahead to demolish the building when there may still be need, under appropriate conditions, appropriate supervision, taking care of safety, for relevant parties, police and others, to gather evidence in the building. So that's our first submission. The second really relates to part two of the proceedings, and it's that there may be lessons to be learned still, and it relates to the inspection question, Chairperson, if it becomes possible. There may be lessons to be learned about interventions that should be made in other buildings that would be gleaned from a closer inspection of Usindiso building. So that's our second submission. But the primary one is that there's evidence. There may still be evidence. And it's not that we're taking a firm and final position on demolition. It's a question of timing, not at this stage. Chairperson, the next issue is the issue of observance and compliance of bylaws, and the evidence leaders make the submission that the observance and compliance of bylaws by law enforcement agencies was almost non-existent. They make later recommendations in that regard. And they point to the difficulty to identify individuals in relation to some of these infractions. We support this recommended finding. We place emphasis on JMPD and GFIS in this context, but not to the exclusion of other entities. And we have made the submission earlier, Chairperson, that both individuals, where they can be identified, and entities should be held accountable. The next issue, Chairperson, deals with other buildings, and it's the evidence leader's submission that buildings that are abandoned, it really draws on the language of the terms of reference. Those buildings must be fenced off to prevent any access by illegal occupiers, or must be demolished. And we say simply on that, Chairperson, that it's a clear Part 2 issue. It relates to other buildings, and what is to be done with them needs full consideration under Part 2. I think the evidence leaders frame this as a lesson to be learned from Usindiso, and we submit that any such lessons or findings must be carefully constrained and focused on the building. Other buildings and the more general approach to be taken are Part 2 questions. Chairperson, the next recommended finding from the evidence leaders relates to intelligence sharing, and it's a key theme of their argument. We support that recommendation. It's a recommendation that the city's entities need to share intelligence information and engage more effectively around buildings in the inner city. We've made one additional submission, Chairperson, which we submit is important. It's, yes, they must engage, but they must also engage with the residents of those buildings meaningfully, effectively. And that comes from cases like Olivia Road and others. But it's also just good policy and good practice. If these buildings are to be addressed effectively, there needs to be genuine engagement and communications with the people who call those buildings home. They are the people who are best placed to help to identify conditions, to address them with the city's entities, and to help to address the issue of crime, to identify criminal elements. And And Chairperson, in due course, this will be a contribution that we hope the Inner City Federation will be able to make, drawing on its experience in organizing in 40 buildings in the inner city. So it's an addition, really, not a qualification, an addition to the evidence leader's submission there. Chairperson, the next is really an issue, a proposed finding around and recommendation around strict adherence to bylaws. We broadly support it, Chairperson, just subject to those important qualifications around respecting legislation and rights. So not bypassing PI and recognizing that in addition to bylaws, there are rights at stake, rights to water and the others. Chairperson, the next recommendation is that the city EMS and the political principles for public safety, health, JMPD, SAPS and JPC must carry part of the blame for the fire. We support that fully. The next, Chairperson, relates to witness X. Chairperson, the recommendation, and I think this is fairly common to the parties, the finding that, in different forms, the finding that witness X caused the fire, which was accelerated by other material. Taking Mr. X first, witness X, Chairperson, we propose a slight qualification in this regard, and it's that the finding be limited at this stage to an expressly prima facie one. We accept that there's a prima facie basis to make a finding in relation to Mr. X's involvement in starting the fire, based on his evidence and the evidence of witness Y and some loose circumstantial evidence around it. But there are some serious questions that remain. The state of mind of Mr. X, the effect that substance abuse had on him, who was the alleged deceased in that incident, questions of the forensics around how the fire was started and how it spread, and Chairperson, and one further one, Chairperson, the role of witness Y, and potentially other people. And Chairperson, it's for that reason that we submit that the finding should indicate that there are further questions, that further investigation is required, but that there is a prima facie basis to make a finding in relation to Mr. X. We've made the submission, Chairperson, Commissioner, that there may also be a basis to make a prima facie finding in relation to witness Y's knowledge. Witness Y's evidence around knowledge coming from fever dreams appears to us, Chairperson and Commissioner, to lay a basis at least for further investigation around her role. And there may be others who need to be investigated. So we support the recommendation, but with those additions. Chairperson, the next issue, the next item really also relates to Mr. X, witness X. I've dealt with that. Chairperson, the following one at the foot of page 4 deals with condemned buildings, other condemned buildings. And it's again framed as a lesson to be learnt. Again, Chairperson, our submission is simply that those are issues for Part 2, other buildings and the approach to them to be determined in Part 2. And care should be taken not to, in the language of lessons learned, inadvertently preempt Part 2 findings. Chairperson, there are then further issues around bylaws, and the first deals in particular with combustible material and building material that was used in the property. And again, we don't oppose this proposed factual finding that the building was non-compliant in that respect. In fact, we would endorse it. But we would add that had the city properly regulated its building and provided non-combustible partitioning material to the residents, that may have mitigated the risk of the fire, reduced its severity. Chairperson, the next relates to fire safety bylaws. We support that recommendation fully. The following, Chairperson, relates to catastrophic outcomes like this being averted if role players in the governance and administration of the city collaborate. I've indicated our position that we support that in principle in relation to Part 2, but the nature of that collaboration is an issue to be explored further, we submit in Part 2. So it played a role, yes, here in this building, but it will arise again in part 2. Chairperson, the next submission relates to the responsibility of the city and its entities. We support it. Chairperson, there's then a proposed factual finding around the number of deceased, and we accept that. It's reducing the number from 77 to 76. We accept that. Chairperson, I'm conscious of my time and I want to prioritize
Yes.
some issues that are still of importance. So let me move with some expedition. The next issue, Chairperson, is the proposal of a memorial, which the evidence leaders make. It's endorsed by the residents. We support it too, Chairperson. But we make an additional point, which is an argument we make in our heads, which is that it's crucial, not just for the memorial, but for much broader purposes, that every one of the deceased is identified by name, and that support is provided, for example, for repatriation of remains that require it, for burials, and so on. We've made those submissions in our heads. It's our submission that process is incomplete, and responsibility needs to be placed on an appropriate official or set of officials and institutions to complete the process of identifying all of the deceased and all of the surviving residents, because there are issues that relate to the survivors too. Chairperson, the next issues really relate to bylaws again, and we've made our position clear on those, including on the Fire Brigade Act and regulations. And we have restated the qualification that enforcement of bylaws must at all times comply with applicable legislation and the Constitution. All of those on page 7, Chairperson, are recommendations that we support of the evidence leaders, and the same on page 8, all supported, and I'll move swiftly through them. If I move them to page 9, Chairperson, there's the issue of electricity. And Chairperson, as we understand the evidence leaders' argument on this issue, it is this. There was breach of the electricity bylaws and an illegal connection, and what ought to have happened was enforcement of the bylaws, disconnection, and the building shouldn't have been receiving supply of electricity as it was. We accept the breach of the bylaws, Chairperson, but we've made our submission that in terms of the city's own policy, the ESP, as conceded by the city, the residents would have qualified for free electricity, and that what ought to have happened is really two processes, Chairperson: disconnection of illegal connections, rendering them safe, and assessment and provision of free electricity in terms of the ESP to indigent households in the building. So that's one respect in which we don't support the proposed finding of the evidence leaders, or at least we submit that there's a key element missing from it. Chairperson, the next issue is a proposal around Pick It Up, and we support that. And the next, Chairperson, relates to allegations against the ward councillor and Mr. Takalani. And the recommendation from the evidence leaders was that SAPS conduct further investigations. We've made an additional recommendation here, which is that the mayor and/or municipal manager should investigate and consider bringing disciplinary processes. Our submissions focused on the councillor, the ward councillor, Nyameni. Chairperson, the next issue relates to the evidence leaders recording certain recommendations made by the mayor in his evidence, and we say that those are part 2 issues. The evidence leaders recommend steps, investigations in relation to the municipal manager, the CEO of JPC, and the head of JMPD. We've supported that and made certain additional proposals in relation to 3 individuals, Mr. Manganye of the JPC, Ms. Boertus, and Mr. Monacheng of EMS, and we've made those submissions in our heads. Chairperson, there's then the theme around immigration, which the evidence leaders deal with in some detail in their heads of argument. And Chairperson, much of that, in particular the evidence of the 2 experts, Professor Hirsch and Professor Kaziboni, we support. But we submit that it is premature at this stage and that those are issues for Part 2. It may be necessary to make some limited findings in relation to the residents, given that some of them were foreign nationals. But all of those systemic issues that the witnesses from Home Affairs and the 2 experts dealt with, we submit our issues for Part 2. I've dealt with demolition, Chairperson. That's at the foot of page 10, and I've made our submissions in that regard. If I might move then swiftly to the city. And I'm conscious, Chairperson, that I've got about 5 minutes remaining. So let me endeavour to focus on the highlights, Chairperson. In relation to the city, there are several aspects in which we do part ways with the city. There is one crucial aspect in which we agree with our learned friends for the city, which is that certain of the issues that have been raised are Part 2 issues, and they identify some questions that are systemic issues. I will highlight, Chairperson, at the outset that the 4 recommendations that the city makes at the end may have some merit in when fully considered and perhaps in a slightly different form. But they are, with respect, all Part 2 recommendations. None of them relate to the building, accountability for the building. They relate to improved dialogue between the relevant organs of state and processes of review of the systemic issues. And we submit for that reason that the city's recommendations made in their heads of argument are questions to be returned to in Part 2. The city's central arguments, Chairperson, are that at this stage there's little to be gained from finger-pointing or making determinations of particular breaches. We submit, Chairperson, that with respect, this Commission's core mandate is to consider responsibility and liability, and there's no shifting away from making findings that relate both to individuals and institutions in relation to what happened in the building. And in that regard, we're largely on the same page as the evidence leaders and the residents. We do accept that there may be other processes that would be beneficial around improved dialogue and engagement, and I've made the point about involving communities in those processes. But those are not a substitute for accountability, Chairperson. And in conditions where there have been 76 deaths, there must be accountability. Chairperson, one issue that I haven't dealt with in detail is, and which does, we submit, also call for certain findings, are the events subsequent to the fire. The evictions, the detentions, the evictions from the shelters, the detentions, and the conditions now in the flood-prone shacks at Denver, where approximately 30 of the South African former residents have been placed. And we've made our submissions in that regard in the heads of argument. We don't see that those have particularly been addressed. And we do submit that while the Commission didn't have powers to intervene, it does now have powers to make recommendations in relation to what the Premier and the local government authorities can do for the residents. Chairperson, our submissions in relation to the residents' submissions I've largely dealt with indirectly as I've moved along. And in essence, we broadly support their proposed findings and suggest some qualifications or additions. I'll highlight a few additional recommendations then that we make. And they're issues on which the residents perhaps touch on, but they don't address us directly. as us. One, Chairperson, and it's a recommendation that we make in relation to a finding, it's the question of the 2019 raid. Excuse me, Chairperson. It's been dealt with by all the parties in argument, and the evidence leaders and the residents really deal with it in this way. They say what the raid did was to make it beyond dispute that the city and its entities knew about the conditions in the building. We agree with that, but we've made an additional submission, Chairperson, drawing on the decision of the Constitutional Court in Industry House, the raids case, which is effectively that raid, its legality has not been established. It has been placed in significant doubt, and we submit that it was prima facie an unlawful raid. The raid was a multi-entity raid which arrested a large proportion of people. It went into people's homes. No witness has identified the legal basis for that raid. When we asked Mr. Monacheng of EMS, who were involved in the raid, what its legal basis was, his response was that he didn't know. He participated in it. Of course, EMS were not leading the operation. But, Chairperson, in the circumstances, we submit that raid, while it may have had some public interest purposes that could have been served, was unlawful, and that it's precisely the sort of raid that was condemned by the Constitutional Court in the Industry House decision, which concerned a wave of similar raids across the inner city, where large numbers of persons were detained. Chairperson, I might make, lest that argument be misconstrued as endorsing criminal activity, I might make one brief submission on crime. And it's something that we certainly intend to return to in part 2. But the essence of it, Chairperson, is this. Raids of this sort don't work to address crime in buildings, and they don't work to improve safety. We see that abundantly clearly in this case. 70-odd people a large proportion of people were arrested, they were released, those were residents who returned to the building. We're not aware whether the 2 people who were arrested in relation to collecting rental were successfully prosecuted. We understand a case was brought, but it's not clear what the outcome was. But these sorts of raids, Chairperson, are not what is required to improve safety or to address those criminal elements. To tackle the crime, what is required is crime intelligence, coordination of the sort that the evidence leaders argue for, and targeted criminal policing activity that identifies those actors and doesn't simply go after the entire building with a sledgehammer approach. Similarly with safety, Chairperson, a policing raid that looks at whether people are undocumented does nothing for the safety of the building, and we know that following the raid, steps were not taken to enforce bylaws. So even those entities like EMS that participated didn't then use their powers under the problem buildings bylaw, the EMS regulations, and so on, to tackle the safety conditions. And Chairperson, the further problem with those raids is the issue of corruption, which has been highlighted in the evidence of the residents. What appears to happen, Chairperson, is that foreign nationals are targeted because they're soft targets for soliciting bribes. And so undocumented persons are detained, they're then swiftly released, and one is left with the inference that that release may well have arisen as a result of corruption. These are issues to which we'll return in part 2, Chairperson, but we do submit that it would be appropriate to make a finding in relation to that 2019 raid, that it was prima facie unlawful and that it was ineffective. Chairperson, I'm conscious of time and I don't want to abuse the privilege. We've made our submissions. The final part of this note distills our own submissions and the responses or attitudes of the parties to those submissions as identified by us or as we understand. Chairperson, if I might just check with my learned junior and my team that there's nothing crucial.
Yes, you may quickly do so, Mr. Brickhill.
Chairperson, there are 2 discrete issues, recommendations that we make that I haven't highlighted. The one is a recommendation for legal aid to be considered for the residents, to support them in the event that they want to take civil proceedings.
Why should you make that recommendation, Mr. Brickhill? I mean, as I see the issue here, we are dealing with indigent people who, in any event, qualify for legal aid.
Chairperson, with respect, we accept that, and at this stage, they may understand that they're entitled to do so.
Yes, they qualify for legal aid funding.
They should do, Chairperson. Chairperson, in a previous life, I was involved in the dispute around legal aid for the Marikana injured and arrested mine workers, and there was some dispute about whether they qualified, and they did ultimately get it. Here, they arguably do. It's an issue about which we are passionate, Chairperson. We raise it. We'll take it no further. And
yes.
They can consider their position. But Chairperson, the other is one final discrete issue, which is the question of, and it hasn't been addressed by the other parties, it was something that struck us, that a large proportion of the senior managers and officials who testified and participated are in acting positions. And on reflection, Chairperson, it seems to us to be a matter of concern. Several of them had acted for many years, Mr. Monacheng, for example. And it's our submission that that's undesirable for two reasons. Effectiveness, performance, and the second is accountability. And so we submit that one recommendation that could appropriately be made is that the city in particular move towards making permanent positions, permanent appointments in those positions.
Yes.
Chairperson, we're indebted to you. Those are our submissions.
Thank you, Mr. Brickhill. Ms. O'Brien.
Thank you, Madam Chair. Madam Chair, before I begin, I am conscious of the time. I don't know if we will be doing adjournments in the usual course today.
Yes, I think it's an appropriate time to adjourn for tea.
Thank you.
Should we reconvene at 25 to 12?
Yes.
Proceedings are adjourned. Yes, Mr. Bryan.
Thank you, Madam Chair. I'm just going to start the timer. Thank you, Madam Chair, Commissioner Mabena, evidence leaders, and my learned colleagues. I appear once again on behalf of the Johannesburg Fire Victims Support Group in our closing submissions. At the outset, we wish to express an appreciation to the Commission for an opportunity to make these submissions, noting that the time constraints have been quite limiting. In order to provide our submissions, we have submitted quite extensive and comprehensive written submissions, and what I will do today is simply highlight key aspects as well as any additional arguments that will supplement the submissions. In order to preface my submissions today, Madam Chair, I feel it is necessary to reflect on the Usindiso building fire and the role that the Commission plays in bringing dignity, justice, and honor to those who died and those who continue to live in the shadow of the tragedy. The residents of the Usindiso building experienced a life in paradox, both in the periphery of societies where their vulnerability created through circumstance and poverty pushed them to the very edge, but simultaneously, they are part of the very fabric of this country. They lived and worked in the heart of the most populous city in South Africa. Johannesburg's very history is rooted in groups of people coming to it in order to build a better future for themselves. From the very roots of the city's history in the gold rush to the present day, it represents a place of opportunity and hope. The residents of the Usindiso building stand in that number of people who wanted to build a better life for themselves. South Africans who came to Johannesburg for jobs as migrant workers, refugees who tried to find a place of safety in this country, and collectively they represented a group of building that found a foothold in the city. Women who had come to the building after escaping cycles of abuse and violence, they all lived there, and their lives were altered forever on 31 August 2023. We note that their circumstances alter perceptions. If this commission had been presiding over an affluent suburb, there would be different public perceptions. The residents have faced narratives, both in the media and through witnesses before the commission, that make it all the more important to advocate for their point of view and their lived experiences. Their experiences often could be interpreted through an external lens, through desktop exercises, or through our interpretations of what their circumstances were. We were very grateful to hear from the witnesses themselves, to give meaning to what those photos represented about their lives in the building. Some of the narratives, both in the media and through witnesses from various entities who sought to evade blame, did not consider the role of the city or political responsibilities who may have had extensive historic knowledge of the conditions of the Usindiso building and the dismal failures to address those by responsible authorities in enforcing safer and humane conditions within a building owned by the city. It was therefore crucial on the part of the victims to ensure that we could unearth the facts of the building through its residents and come to conclusions using their narratives to supplement the facts. Those narratives that don't serve simple agendas of sensationalizing and diminishing their lives and deaths, but give true meaning to the commonalities that our lives and the lives of all South Africans had with the Usindiso building. Of the 500 victims estimated to have been impacted by the fire and affected by it, 240 told their stories to this commission through witness statements, and 42 had the bravery and courage to appear before this commission in person, often reliving trauma and shedding tears, but also shedding information so that this commission could sift through a large volume of information in order to enact some truth. At all times, the Johannesburg Fire Victims Support Group has tried and endeavored to assist the Commission as best as it could within its capacity in this task of truth-seeking, in terms of assisting the Commission in its mandate to inquire into the circumstances surrounding the fire and making findings as to who must shoulder liability or responsibility for the state of affairs, deaths, and injuries. Additionally, we note that the Commission is also to make recommendations as to appropriate steps. I make reference to the Constitutional Court in the Secretary of Judicial Commission of Inquiry into allegations of state capture, corruption and fraud in the public sector, including organs of state, versus Jacob Zuma in 2021, where the Constitutional Court comments on commissions of inquiry, saying the following, and I open quotes: "In addition to the function of advising the President, a commission of inquiry may also serve the purpose of holding a public inquiry in respect of a matter of public concern. The purpose of public hearing under those circumstances is to restore public confidence in the institution in which the matter that caused concern arose. Here the focus is not on what the President decides to do with the findings and the recommendations of a particular commission. Instead, an objective is to reveal the truth to the public pertaining to a matter that gives rise to public concern." The Constitutional Court continues to quote this purpose in saying that in addition to advising the executive, a commission of inquiry serves a deep public purpose, particularly at times of widespread disquiet and discontent. I close these quotes. We acknowledge the vital role that this commission plays in both addressing the disquiet in the state of affairs in the city of Johannesburg and with specific focus on the tragedy of the Usindiso fire. The submissions before yourself and Commissioner Mabena, Madam Commissioner, we've attempted to set out as comprehensive as possible the following. Submissions intended to present the victim's narrative in a manner that emphasizes the human impact of the tragedy, an attempt to simplify the vast body of witness statements and raw data, the process of which was an extensive process also set out in these submissions, in order to assist the Commission as best as possible, to identify procedural or systemic challenges experienced by the victims through this process, as well as emphasizing constitutional rights that had been implicated or violated in the fire, extract evidence-based examples of the dereliction of duty by organs of state before, during, and after the fire, as well as additionally providing the expert opinion of Mr. Ruot, who makes commentary on the national building regulations and building standards in our submissions. We place these in we place this information before the Commission in order to make recommendations as to the proposed findings that this Commission might make. If I may then guide yourself, Madam Chair and Commissioner Mabena, through the submissions on file from page 15 onwards. We set out the undisputed facts before this Commission, namely, and these facts are relevant in that the City of Johannesburg was the registered owner of the building. As the registered owner of the building, there were certain legislative duties in respect of health and safety. Furthermore, as a relevant local authority, the City of Joburg had certain legislative duties in respect of non-compliant, structurally unsound, and or abandoned buildings in the City of Johannesburg, that a lease was concluded by the City of Johannesburg with Usindiso Ministries on 1 July 2003 for the purpose of operating a shelter for abused women and children, that this lease was for a period of 10 years and expired factually on 30 June 2013, that the Usindiso building was occupied both by South African citizens and foreign nationals, and that following the declaration of the building as a hijacked building in 2019 by the city, no further visits or maintenance was conducted or any real meaningful intervention. We can accept that the conditions in the Usindiso building were unsafe for human habitation, that it was densely populated and overcrowded, that informal shacks had been erected throughout the Usindiso building, particularly on the basement floor, that the Usindiso building was not fire safety compliant and had no residential water supply, and that the residents, as we have heard, obtained water from domestic use from fire hoses. We submit further that the termination of the residential water supply was not performed in a procedurally fair manner, and that there was a lack of Additionally, the lack of adequate residential water supply contributed to and/or could potentially have exacerbated the fire and the attempts to address it. We note that various illegal connections had been made at the Usindiso building, on the night, however, of the Usindiso fire, there was no active electricity supply to the Usindiso building as a result of a power outage that had begun with load shedding, that the accumulation of waste inside the Usindiso building had increased the fire load and acted as an accelerant, and that there were various personnel from the City of Johannesburg, the JMPD, and SAPS who had attended the Usindiso building regularly and were aware of the conditions of the building and its residents, but did not make any intervention. We accept that it is also an undisputed fact that the non-compliance of the Usindiso building in respect of fire safety contributed to loss of life, and that despite institutional and historic knowledge of the conditions of the building, crime in the building, and the structural challenges of the building, that the City of Johannesburg did not intervene. We also would like to set out that it is an undisputed fact that at all times a municipality owes its constituents good governance. We set out in some detail the disputed facts that have arisen during this commission, noting that as the representatives of the Johannesburg Fire Victim Support Group, we had raised concerns as to the adequacy of resources available to EMS, the adequacy of resources available to disaster management, the extent of the City of Johannesburg's non-compliance with its constitutional obligations to provide a safe and healthy environment as enshrined in Section 152 of the Constitution, the extent of Councillor Mnyameni's knowledge and/or involvement with the Usindiso building fire prior to the fire, including interactions with the residents, the extent of the COJ and its entities, including City Power, Pick It Up, and Joburg Water, in terms of their knowledge and maintenance of the Usindiso building prior to the fire, as well as the disputed allegations of residents concerning certain city officials and councillors in terms of the allegations of the shacks built and rented out to residents and profits derived thereto. We've also raised the issue that is still in dispute as to the extent of involvement of SAPS and/or JMPD officers in eliciting bribes from the residents and/or criminal elements within the Usindiso building without proper escalation to the relevant channels. The majority of the context provided in the written submissions relates to the following, and I will continue to take yourself, Madam Chair, and Commissioner Mabena through the written submissions. From page 18, we contextualize the victims in their existence and lived experiences in the building, as well as the hostilities experienced in Johannesburg. We set out that affordable housing is at the crux of the issues faced by residents in the inner cities, particularly those in the Usindiso building, who came to the building and lived there in the conditions that we've heard and seen at this commission, because it was the only affordable option they had. Was the building totally unfit for human habitation? Yes, it was. Was it also the only option many of them had? And for some, they even expressed that it was the best option out of the other alternatives that they had been able to identify. Most of the residents of the Usindiso building were gainfully employed, either in formal or informal sectors. Many residents purport to have been operating as sole proprietors of small business, including the repair of goods, sale of second-hand goods, or the sale of food in and around the Johannesburg CBD. Their journey to the Usindiso building and their proximity to the CBD was in an attempt to make a meaningful life for themselves, where they could find gainful employment in a country that has huge challenges with unemployment. In the wake of the fire, many narratives placed blame on the residents for the tragedy. Their narratives in the court of public opinion arose not only outside this commission, but from witnesses who appeared before this commission. It does not consider, as my colleague Mr. Brickhill said, that the victims were not all participants in the crime, but simply people trying to make a way. We've heard from, as I said, 42 witnesses who described their lives, described their struggles, and described their losses in the building and their struggles with building a life thereafter. They themselves were victims of the circumstances of the building, including the crime that did inhibit some parts of it, but where we hear that they themselves erected gates and tried their own security measures from floor to floor to combat that crime, which they were often a victim of. We set out from page 20 a timeline of some of the residents in the building describing different waves of residents. First, the woman who had lived in the shelter, followed by 150 residents of the Emakoseni settlement who had entered the building in 2019 after their own struggles with finding stable housing. And then over time, in a period between 2020 and 2023, where foreign nationals came to live in the building. The character of the Usindiso building was multifaceted, and we must take that into account when we contextualize the residents and their submissions. They are a unique client to represent. They are vast, they are informed by poverty, by disaster, and by an ongoing struggle that persists to this day. That said, I now turn to page 21, where we touch on the narratives relating to the victims. In the aftermath of the fire, this commission will note that there was a recusal application relating to xenophobia at the commission. And we appreciate that the forum was given to fully explore this and make submissions as to the residents' feelings on the subject. That this hostility rooted in xenophobia has appeared, however subtly, through many testimonies. The residents are often described as being hostile, as being the cause of maintenance not being enacted, without any steps described as to how that could have been overcome. The residents of the Usindiso building are not perfect victims, nor do they have to be. The city of Joburg at all times remained capable of addressing the building and its residents as both the owner and the relevant authority, and it was mandated to ensure compliance. It is not enough to say that there were hostile elements in the building and that as a result of that hostility, the building at large was the cause of its own problems. That cannot be said when there was a legal obligation. Foreign nationals who lived in the building did not interact by their own account with COJ officials outside of raids where they had been routinely arrested or elicited for bribes, and or where law enforcement attended the building, but the criminal elements who were arrested were not detained for very long. The stories of the victims cannot be marred by the biases that can often inform looking at people who live in the inner city, who are afflicted by crime or live alongside it. The demographics of the victims we set out at paragraph 38 on page 23 of our submissions. We felt that it was important to illustrate the nationalities, gender distribution, and outcomes derived from the statements of the victims. From our analysis of the body of evidence from the victims, it was clear that the majority of victims who we had interviewed were South Africans and that they had rented their rooms from landlords. Almost all the victims had lost their possessions, livelihood, and homes in the fire, and as a result, many of those possessions who hadn't been consumed by the fire had been lost as a failure of the building being properly secured as an active crime scene. The demographics of the victims being included is also important to counter those narratives of xenophobia, anti-foreign sentiment, and victim blaming on the basis of purely the perception of foreigners in the building, as has been set out by external parties to this commission who have xenophobic rhetorics. page 24 of our submissions, we cover the evasion of accountability by the City of Johannesburg. We set out that the context of the building is also historical, placed centrally in the historical injustice of apartheid, with the continuing access of inequality and limited access to adequate housing for generations of black people. It has laid the foundation for stark disparities in housing and living conditions between the have and have-nots in South Africa. The often misdirected blaming of the so-called illegal foreigners is used as a leverage point to excuse failures to address the urban housing crisis. The lack of spatial planning for urban migration of South Africans within this country contributes to why Johannesburg is such a populous place. But instead, we are faced with diversions that obscure the truth that it is not only foreign nationals who live and work in the inner city and live in these buildings, but South Africans themselves who have been failed by the government in terms of adequate housing. The city's response to the victims of the Usindiso fire strikes at the heart of what it means to be poor and black in South Africa, that the victims of the fire were criminalized for their circumstance of being poor and reduced to little more than public nuisances when described as challenges of government or the city doing its work. They remain confined in the dark corners of our society, and based on many responses where victim blame is shifted either to the victims or upward within the structure of the City of Johannesburg, that decenters any accountability for their circumstances. Throughout the Part A hearings, in both examination in chief and in cross-examinations, as I said, there was an evasion of accountability that either placed blame at the feet of the victims or deferred to another entity. We set out a table at paragraph 47 on page 25 that illustrates examples of this within the transcripts of the hearing. Through these transcripts, which covers many of the victims we've heard from different departments within the city and its ecosystem, there is an evasion. There is a movement away from taking accountability or an admission of responsibility. My apologies. Madam Chair, I now move to part 2 of our submissions, where we address key themes. The victims have faced an unjustifiable limitation of their constitutional rights, and we set this out from page 43 of our submissions, where we set out the violations both before and after the fire. Not only, as I've stated before, the access to adequate housing, but also the temporary emergency housing that was provided to the victims, which, as we've heard in this commission, have also been the creators of further dire circumstances, as they have been prone to flooding and criminal elements that we addressed both before this commission through some witnesses, as well as the concerns raised at the urgent court case, which this commission is aware of. We set out that there is a bedrock of rights violations experienced by all victims, regardless of their nationalities. Before the fire, and we set this out at page 44, we set out that the adequate housing in terms of Section 26 and the state's obligations in terms of that right do not extend beyond the progressive realization of that right. However, it does not mean that the right is entirely unqualified. It is submitted that the unsafe housing, which the Usindiso building unquestionably was, did not meet the standard of adequate housing. We cite various judgments that establish that a right to adequate housing extends beyond the obligation simply to provide a housing structure. We look to Grootboom, where it was held that housing entails more than bricks and mortar. It requires available land, appropriate services such as the provision of water and the removal of sewage and financing of all of these, including the building of the house itself. For a person to have access to adequate housing and all these conditions to be met, there must be land, there must be services, there must be a dwelling. I close these quotes. It follows that adequate housing must include services. We've heard before this commission that the services provided to the Usindiso building were wholly inadequate. The state's obligation to provide housing comprehensively is subject to the requirement of reasonableness, but reasonableness must be constitutionally understood. At page 46, we again turn to Grootboom, which contextualizes this, saying that the right of access to adequate housing is entrenched because we value human beings and want to ensure that they are afforded their basic human needs. A society must seek to ensure that the basic necessities of life are provided to all if it is to be a society based on human dignity, freedom, and equality. This strikes to the heart of the issue faced by the Usindiso building. The victims are people. They did not have life-sustaining resources provided to them. The right to adequate housing, by extension, is an expression of values that underlies the Constitution. We submit that reasonable provision of adequate housing must have regard to the constitutional rights of the people living in that housing. The Commission has heard that the Usindiso building was deeply unsafe, that the crime, drug use, informal structures put in the building by residents endangered their safety and well-being. We submit that in respect of these conditions and respect of the knowledge, the deep institutional knowledge that has been demonstrated throughout this commission in its examination and cross-examinations of witnesses in the state, that there was knowledge by the city, there was knowledge by various entities of these conditions that fundamentally violate the rights of the residents. Their dignity, their safety, all these things remain compromised in the aftermath of the fire. Madam Chair, in order to just move on, I do note that before the fire we have set out the rights that had been violated, but I move now to page 49, where after the fire we also set out the various instances in which there had been violations of rights. Let me just. In the aftermath of the fire, this commission has heard about the issue of temporary emergency accommodation. In cross-examination of Mr. Roy, we heard that international best practices had not been duly followed. Many residents remained in what was meant to be temporary for 72-hour facilities for much longer than that before they were moved to either the Lindela detention facility for deportation or to Denver, which presents its own host of issues. We set out in quite extensive detail the manner in which the aftermath of the fire constituted many violations of rights, including the the rights to safety, education of children, the structural and infrastructural issues of Denver, where many victims remain, and how, in terms of South African law, these issues constitute a continuing violation of rights. I move now to page 53, where there is a submission on the terms of reference in respect of the treatment of foreign nationals. We make submissions as to the limitations that the terms of reference provide in terms of assisting the foreign nationals, and set out that the goodwill of the state, as promised at the very beginning of these proceedings, did not last in the ways that the ongoing separation of victims, where families of both foreign nationals and South Africans in one family were separated, that the arrest of foreign nationals constituted a threat to this commission, as we had not been able at certain points to gather those victims whose testimonies we feel were central to bringing information to light. We set out at page 54 the persecution faced by the state at Lindela, noting I've been informed that despite the interdict, some of the residents who remain at Lindela have already been deported or in the process of being deported. We set out extensively the background information and context of the legal assistance and legal court case before Judge Dossio in respect of the evictions in November of 2023, as well as setting out the Lindela, the residents who were at Lindela. At 57, we set out how the rights of foreign victims were violated, in particular, their rights to dignity, freedom, and security, and their rights as a detained person, more broadly, which we've set out had been infringed throughout their long months of detention at Lindela. We set this out in quite extensive detail, and I note that my time is limited, so I will move forward, Madam Chair. Madam Chair, at page 60, I do wish page 61, I have been informed by the evidence leader that he had taken issue with, I would assume it was paragraph 129.1, and we would just like to address that in order for clarity with the evidence leader himself and for the Commission. At paragraph 129.1 on page 61, we set out an example of a witness talking to the various rhetorics in the narrative at this Commission in reference to the broad generalizations as perceived by the residents, and our duty as their legal representatives to communicate that to the Commission. This reference was not to malign any parties of this Commission, but rather to highlight that from the witness perspectives, we had noted a pattern of rhetoric being repeated. The generalizations themselves are not simply just this example, but through many, many witnesses who had used the fact that there was crime, foreign nationals, and unknown elements as an excuse to evade accountability. It was in no way intended to offend, but rather to contextualize the basis of that generalization from the perspective of a witness. As I had already addressed earlier, we have extensive submissions on xenophobia, but I move now to page 63, where we set out the
Ms.
legal...
O'Brien.
Yes.
Is it your submission that this commission is competent to decide issues about xenophobia?
I would say that it is an issue that the Commission could take into account, given that it is an issue that has arisen as a point of concern from the residents, specifically in the context in which the residents have been treated by state officials and city officials throughout their experiences describing it. We also think that given the outset of this very commission, where the issue of xenophobia was an issue for the point of recusal and was then removed as an element, it is something that is noteworthy and significant given the portion of foreign nationals who have been affected both by systematic and structural inequalities and violations of rights, where some of those violations have been as a result of xenophobia at a state level. But it is an additional issue that I feel the Commission is empowered to comment on in terms of the terms of reference. Shall I continue, Madam Chair?
Yes, you may.
Thank you.
Proceed.
We set out at page 63 the legislated duties of the city as a local authority and its obligations, setting out both references to the Municipal Systems Act, the sub-entities of the COJ as listed as Pick It Up, Johannesburg Water, City Power, the JPC, JOSCO, EMS, and the JMPD. All these bodies feeding in to the City of Johannesburg are obliged in terms of both a framework of legislation, as we have set out, to provide services, duties, compliance management, and all the checks and balances that should have been in place for the Usindiso building to ensure that it was not a victim of the tragedy that it was. We set out at Annexure P, which is in the bundle, the various obligations of the City of Johannesburg through its sub-entities, as well as make references to these obligations as set out in the transcripts of the hearings. As an owner, in addition to being the relevant authority, the city also had obligations. We set this out at page 71, including both Mr. Ruert's report as an expert on the obligations of the city, as well as an assessment of the access to basic services, the issue of the so-called abandoned buildings within the City of Johannesburg, as well as the context which informs those buildings, and the lack of political priority given to the Usindiso building and many buildings like it, noting though that that is a Part B issue. Where political figures were cross-examined by this commission, there was a lot of information held but not acted on. And much of this inaction was blamed on, well, the administration changed, I couldn't escalate these issues, but we set out that the duty remains. If a new administration takes office, the duty remains to be fulfilled by any party who is in local government to ensure that there has been sufficient address of systemic issues and that there isn't political scapegoating simply because there is a change of administration. At page 75, we set out the issue of the hijacked buildings, so-called, where immigrant populations are said to be the primary residents of such buildings. Usindiso illustrates that the primary residents of the building had many South Africans. It was not simply, it was a rhetoric that we needed to dispel, given our interactions with the residents who were South Africans and who lived alongside foreign nationals, yes, but were not in a minority in the buildings, as is often suggested in rhetorics relating to hijacked buildings. The term hijacked buildings was often used at this commission by certain city officials as a scapegoat term. Well, their hands were tied because it was a hijacked building. They couldn't do anything because of it being a hijacked building. We say that at page 76, this simply avoids addressing underlying issues relating to governance, resource allocation, and urban planning, where the challenges for service delivery often stem from within the municipality itself. The shifting of blame only reinforces biases against these communities. At part 3, which, Madam Chair, you'll find at page 77, we set out our argument in terms of the relevant legal considerations. We make submissions to this commission in terms of our view of who must shoulder liability and responsibilities for the deaths, injuries, and homelessness that resulted in the Usindiso fire. Ultimately, as our submissions reflect, we recommend that the City of Johannesburg should be found liable and responsible for the deaths, injuries, and homelessness that resulted from the fire. Further in our submissions, we indicate that the liability and responsibility should not lie solely with the COJ, that it should extend through various sub-entities and officials and employees all who should shoulder liability and responsibility for the injuries and deaths that resulted from the fire. We set out with extensive submissions as to this liability from page, apologies. My apologies, Madam Chair. From page 97 and page 100 are where those findings on liability find themselves. But in order to contextualize them, we first set out from page 79, Madam Chair, additional findings that we feel are within the scope of this commission in terms of the terms of reference to focus on. We touch on these submissions in particular of Helen Boertes, the Chief Executive and Accounting Officer of the JPC, and the evidence of Kabelo Gwamanda, the Executive Mayor of the COJ. In our submissions with these two witnesses in particular, we set out specific issues where the facts gleaned from this commission, the timelines and the responsibilities and the failures and non-compliance with legislation are set out in these sections in order to contextualize our submissions about additional findings that this commission should make. We also note that the bodies that had been tasked with the responsibility of overseeing these buildings did not provide this commission with any interim findings that had been made. There were no internal investigations that had been alluded to that had already occurred that could come to this commission, and both for the victims and for the purpose of this commission state that these were their interim or preliminary findings and that the disciplinary proceedings had already been ongoing. It is more than 6 months after the fire or thereabouts, and we have yet to hear about steps taken factually without the recommendations of this commission before it, but steps taken by a body, namely the City of Johannesburg, that should have already been taken at the outset of the fire to identify failures, weaknesses, and areas of improvement that, when cross-examined, could have been addressed. Instead, we were met with evasion, the constant refrain of no comment, and what felt like a vague allusion to disciplinary proceedings happening with no real consequence of what that could mean from a civil and criminal liability perspective. This commission should make findings on liability that reflect the seriousness of the losses in the fire and the dire circumstances where the COJ was both the owner of the building and the relevant authority. This liability should extend to more than just an internal slap on the wrist, and there should be feedback demanded that can be escalated where applicable. In many instances where the City of Johannesburg failed to act in accordance with its obligations, despite a legal duty to act, the Usindiso fire could have been foreseen or addressed long before the fire broke out. We have heard at this commission that some of these plans, as set out by the city, have been running since 2011, but not effectively. It is insufficient to speak of plans being put in place, disciplinary procedures being intended to have been carried out, when an ongoing failure to act, to implement legal duties has led to a crisis within the inner city of Johannesburg. We cannot hold the City of Johannesburg to a different standard as other owners of buildings in terms of health and safety law. If what had happened at the Usindiso building had occurred in a luxury apartment block in respect to fire exits being blocked, exit paths being insufficient for safe search and rescue, the relevant owners would be held liable for the failures. The city can't be held to a different standard when what is at stake is a loss of life, a huge loss of life that was unprecedented in this country. There is even a higher standard as both the owner of the building, but also the relevant authority whose mandate it is to ensure that the law is upheld in relation to health and safety. The City of Joburg is a public entity meant to take care of its citizens. Therefore, we feel that the victims deserve that liability is placed at the feet of those who had the responsibility to ensure their safety. Instead, what we have had at this commission has been upward blaming, shifting of blame, and evasion of blame. Accountability is key as an outcome before this commission. At the very least, compensation for the victims, as we have set out, in order to, as a preliminary start, allow them to restart their lives. At page 92, once again, we set out applicable law to the city as a municipality, setting out its constitutional and general obligations. We set out at page 94 the legislated obligations that I speak of, as well as the obligations in terms of bylaws. We then set out at page 96 instances where, or rather submissions where, the City of Johannesburg breached these obligations as set out. These breaches often occurred by way of omission or inaction in relation to the Usindiso building, where there was an obligation to act, but a failure to do so. Moving to page 97, in consideration of these duties and a failure or omission to act, we then set out that the liability of the City of Johannesburg criminally is constituted because many of those breaches of the applicable legislative instruments are offensive, that there has, through the evidence of this commission, been an indication of extensive non-compliance of legislation, and that these breaches may give rise to criminal liability in terms of those instruments themselves. We set out that the failure to act in accordance with the obligations were negligent, that there was no justification for the deaths of the victims of the fire, and as a result there was unlawfulness, and that the failure to act, in particular a failure to ensure that proper firefighting equipment was present in the building, and multiple failures to ensure compliance with fire safety related legislation caused deaths. We don't seek to prove or establish criminal liability. Instead, that we want to highlight that it's a matter that should be considered by this commission as a relevant consideration in its findings. It's respectfully submitted that this commission is empowered to refer any potential offences to the appropriate authorities, and we submit that the commission, on the basis of the submission set out in our written statements in terms of the breaches, is empowered to make such referrals. The issue of civil liability from page 100 sets out in a similar manner the overarching surrounding context of both the breaches in where there was a failure to act despite a duty to do so, as well as our suggested findings at paragraph 197, which sets out that the Commission is also additionally empowered to make clear findings in respect of the negligence and inaction and the responsibilities thereof on the part of the City of Johannesburg. We set out at page 101 the issue of responsibility, noting that in terms of the terms of reference, these are issues in terms of responsibility and an inquiry into the circumstances of the fire. We submit that the Commission, in clearest possible terms, should make findings in respect of the City of Johannesburg in terms of the responsibility and additionally the lack of accountability for those failures. I have addressed the issue of disciplinary proceedings, and I will now move to the concluding submissions, noting I've only got 10 minutes left. The recommendations of the victims are as follows, rather. Owing to the extent of the City of Johannesburg's accountability for creating conditions which led to the fire, we submit it would be apposite for the Commission to recommend the payment of compensation by the state on the basis of loss without liability to the following persons. This is at page 104. dependents of the deceased who died in the fire, dependents of the deceased who died after the fire having succumbed to their wounds, the surviving victims who sustained physical injuries from the fire, surviving victims who lost everything they owned in the fire. Categories of victims referred to ought to include both South African citizens and foreign nationals, whether here legally or illegally. The proposal for payment of compensation is appropriate for various reasons. We set this out at page 105. That firstly, it would bring closure to this shocking chapter in the city of Johannesburg's history, and that to the best of the Johannesburg Fire Victim Support Group's knowledge, delictual actions have not been instituted on behalf of any dependents of the deceased or surviving victims. We submit that in the event that the Commission finds the City of Johannesburg or its entities or sub-entities should shoulder the responsibility of the fire, the payment of compensation, as aforesaid, would be a necessary and appropriate consequence. We therefore have made the following recommendations for liability: that a finding of civil liability for the City of Johannesburg and its sub-entities would be appropriate. We then list those sub-entities, that there is a prima facie finding of criminal liability of the City of Johannesburg and its listed entities, and that vitally, that there is an investigation into the City of Johannesburg and its sub-entities in respect of the Usindiso building fire. That this commission, empowered by the terms of reference, makes a referral of a complaint to the Minister of Police and National Commissioner of the SAPS in respect of the conduct of members of the SAPS, specifically from the Jeppe Police Station and Johannesburg Central Police Station, whose conduct, despite being part of the narratives of the victims of the fire, was not fully excluded, as it is beyond the terms of reference of the Commission. The conduct of the officers, as set out in this forum, warrants scrutiny in the wider context in terms of law enforcement and the lack thereof at the Usindiso building.
Ms. O'Brien?
Yes.
Inasmuch as that's a laudable recommendation, how is the Minister or the National Commissioner supposed to investigate the conduct of the members of the SPS in circumstances where there is no knowledge of the identities of such members?
Madam Chair, I take the question. Many witnesses from the building have themselves said, though we may not know the names, we would be able to identify those police officers. They would
be able to identify.
They've said they could facially point those.
I don't recall such evidence.
Well, my apologies, Madam
I
Commissioner.
don't have that evidence before me.
I may be confused then, but
Yes,
I do.
you are confused.
But I do. That evidence was placed before us at Norton Rose. That
is not the evidence that was laid before this commission.
we can make additional supplementary submissions in that regard, but I can withdraw that statement as it may have been unqualified in terms of the commission. But would it not be appropriate that an investigation is looked into on the basis that many of the residents did purport to the SAPS and JMPD being within the building, that they had personal experience with those officers? Many residents had been detained or could recognize officers who had been regular occurrences at the building for the purpose of either eliciting bribes or interactions with the criminal elements, as had been described. Many residents had been consistent in their testimonies that the law enforcement attended the building on a not infrequent basis, and that it was not an unusual sight. Therefore, I feel that there's enough scope for some investigation to be taken into that, as well as the treatment of residents who had been arrested after the fire. But I do take your point, Madam Chair. We further submit that there should be humanitarian assistance provided to the victims, including but not limited to suitable housing, psychological support, support in pursuing gainful employment, assistance with regaining their identification documents, and education for minors who were affected by the fire. In conclusion, we also ask for compensation as described above. As Part A draws to a close, we are reminded of the profound responsibility entrusted upon this Commission to seek truth, justice, and accountability in the face of unimaginable loss. Over the past few months, we have delved into their stories, their losses, and their accounts of being vulnerable members of society in this country. The factors that the victims were affected by set out their circumstances of birth, class, and wealth. Often, these factors can bar people from justice, but through this Commission, we have been able to aim for more. That their rights are theirs by virtue of being alive, by being people, and that those who perished in the fire are owed justice as a result of the truth being brought to light. The victims' testimonies has revealed many failures and neglect by the City of Johannesburg and entities that allowed for conditions to fester to allow for a tragedy such as that of the Usindiso fire to occur. We set out that the severity of loss of life could have been prevented with appropriate interventions by the City of Johannesburg, who was tasked with such intervention by law. The deaths of those who died in the Usindiso building fire were not inevitable, and they were not the fault of the victims, but a consequence of neglect and disregard for the safety and well-being of the residents by responsible parties. The aftermath of the fire serves as an urgent call for the creation of a comprehensive urban development policy that not only prioritizes the provision of safe and affordable housing, but also promotes inclusive policies that address the needs of different communities. We hope that the Usindiso fire can serve as a reminder of how dire consequences can be, where public services and municipalities allow those who live on its periphery to slip through the cracks of poor service delivery and apathy. We trust that the Commission, in its report and in its task of ensuring that those lives that were lost will not be lost in vain, and that through the Johannesburg Fire Victims Support Group submissions, that more light could be shed to ensure that history may never repeat itself in the City of Johannesburg and South Africa as a whole. Thank you, Madam Chair.
Thank you, Ms. Suprain. Mr. Mukwena.
Chair, I realize that it's 10 minutes before the lunch adjournment. Even Kaizer Chiefs, my team, would never score a goal in those 10 minutes.
You may just be the person to do that. I think we'll take your submissions.
Yes. You should
proceed.
Honorable Chair and Commissioner Mabena, for a sensible treatment of the issues arising in this Commission of Inquiry, the CTF submitted comprehensive written submissions, and for the purpose of our oral address, we propose not to read our heads of argument, but to highlight the main themes upon which the submissions are anchored. However, Madam Chair and Commissioner Mabena, prior to making our submissions in any meaningful details, may you permit us to make 7 overview yet pertinent submissions. We do so having carefully listened to the submissions already advanced. It would not serve any purpose for us to repeat what we've recorded in our submissions, but it will serve a better purpose if we mainly highlight what we believe are the 7 broad issues that ought to be dealt with as our overview submissions. In turn, Chair, those overview submissions will present or provide the Commission with the helicopter view of our main submissions. And to the extent that we're now dealing with our main submissions, we will endeavor not to repeat what we have said premised on the 7 overview submission. The first one that one has to make, and we believe that it's befitting to do so, is that an acknowledgement that on the 31st of August 2023, a very unfortunate incident happened where life was lost of almost 76 human beings during the Usindiso incident. It does not matter for the moment, as suggestions could have been made, whether that life that was lost was of South African citizens or of foreigners. What is critical is that human life was lost, and that point must be made upfront. And the second one that you wish to make is that appreciating and understanding the parameters of this commission, which are inquisitorial in nature and not adversarial. The mandate which we, as the legal team of the city, sought to carry out in our brief. We are not here to defend any individual, but our mandate, we understand, is to assist this commission through its difficult task in pursuing the terms of reference and in also ensuring that it is able to make informed factual findings of what transpired. And thirdly, under our view, under our overview submission is the fact that it matters not, Madam Chair, for now, whether or not the fire was caused deliberately or otherwise. What matters are the lessons that ought to be learned from this incident in order to avoid such a tragic event to occur again in our country. This therefore means that the Usindiso incident provides us with an opportunity to make an introspection and to reflect and to see how best can these issues be avoided in future. The fourth point that we wish to make, Chair, is that to the extent that there might have been bylaws which were not observed or implemented or enforced, a finding must be made as such. However, such a finding must be made with one having to balance the roles and obligations of those that occupied Usindiso building and the role and obligations of those that were called upon to enforce those laws and the bylaws. What are we saying? In essence, we are saying that the report of this commission should not be misconstrued to send a message that it doesn't matter how anyone conduct themselves illegally, and it doesn't matter how they may want to justify what occurred at Usindiso through illegal means without having, with simply having to overemphasize the question of the bylaws, which could or might have actually not been enforced by the officials concerned. We are saying that there must be a balance strike in looking at the totality of the evidence and at looking at the different roles. The fifth point, Chair, that you are making is that in those instances where the Honorable Commission makes a finding of fact that there might be prima facie evidence pertaining to any dereliction or abdication or neglect of such certain duties by any official, such a finding must be made and should be made as long as one understands that this is not a commission or a forum where one can pronounce on the guilty verdict of those individuals. In this regard, the commission must recommend that due process must be followed for those officials, correctly so, to be able to account before the relevant forum in order for them to be able to exercise any of their rights as contemplated in Section 23 of the Constitution read with the relevant provisions of the LRA. We are issuing that caution in the light of what one seems to see in some of the recommendations that are made, which might appear that already this is the commission whereby those individuals would be found guilty of any conduct as suggested. The sixth point that you're making under overview submission is that acknowledging, Chair, and accepting that there are obligations on the state, in particular the city, in this matter or in these proceedings, to provide services to individuals. Equally so, there must be a proper weighing of the obligation with a corresponding obligation for individuals to respect the law, not to resort to self-help, not to resort to illegal conduct in order to derive those services. That message must also become clear in the report of the Commission. The last point which you are making under the overview submissions is that South Africa is a constitutional democratic state, and the Constitution is the supreme law of our country, which entrenches within it the Bill of Rights. Not only is the South African government, South Africa governed with reference to the Constitution, but also by a number of body of statutes and law, which governs our conduct, Chair. In this regard, paramount to those instruments is the rule of law. Accepting and acknowledging without any qualifications that organs of state are obliged to implement and enforce the laws of the country, including the bylaws. One should not lose sight of also the responsibility of us as citizens or of any other person that visits our country to also have regard to the rules of the country and to respect the law premised on our Constitution. Now, we are saying this because it can never be a justification, factually or legally, for one to approach any court or any entity to say, I might have been hungry and I might not have means, and therefore I took it upon myself to go to a shop and steal. That can never be something which one can consonate in the light of the parameters of our law and the rule of law. The mere fact that I cannot afford to buy a vehicle does not suggest that I've got any right to resort to criminal activity and hijack anyone's vehicle. The mere fact that the building stands vacant and empty does not entitle anyone to have illegal access to that building. What we are saying, we are cautioning against a one-sided view to say that what the officials ought to have done, accepting unconditionally that they ought to have done certain things, accepting unconditionally that they must actually implement and enforce the bylaws. One should not lose sight of the very same conduct of the individuals that occupied the property. Because we are living in a country where we believe that it's not a lawlessness country, it's a country that is governed by statutes, and all of us are bound to follow those statutes, irrespective of our condition, irrespective of our background. Even those that might be coming from the worst situations and conditions in our country, they still know that they have to observe the law. Those then take in totality what we wanted to address as our 7 overview submissions, and we believe that those 7 overview submissions addresses quite a number of issues emanating from either the submissions of SERI or the submission of the concerns a group of I'll get the name, the one that Mr. Supremo was actually representing.
Not in Rose's submission.
Yes, not in Rose submission. And we believe that we should have that balancing act. There are only two main issues which we want to address. And as a roadmap, Honorable Chair, those two issues are the obligations of the city as the owner and as a municipality that has to implement the bylaws. We won't shy away from that topic. And the second topic we wish to address very briefly is the constitutional obligations of the city and its entities to provide the services. I'm not sure whether we should proceed, Chair, or we...
Yes, we must proceed.
Yes.
You must complete your submission.
Chair, yes, that will benefit us if we are going to proceed to the end. Chair, we are now dealing with those two topics in turn. We're starting with the obligations of the city as the owner and its obligations to implement and enforce the bylaws. We find comfort in the submissions ably and eloquently drafted by the evidence leaders. May we invite the Honorable Commission to read with us what is being captured on page 9 of the aforesaid heads of argument. We place much more reliance on what is ably set out from paragraph 16 to page 11, paragraph 22. And we agree fully with what is being observed, and we agree that that captures the essence of the evidence pertaining to what was occurring at Usindiso, and we submit that there can never be any contrary submission to negate what is captured there.
You said it's page 11, paragraph 22.
Page 9, I beg yours, page 9, paragraph 16 to page 11, paragraph 22. We will also touch on paragraph 25. Permit us, because of their centrality and importance, and as we are reading them, we'll make submissions to also read them into the record. At paragraph 16, the evidence leaders ably and eloquently say the following: when the building became overpopulated, basic municipal services such as water services, electricity services, and wide encompassing waste management were not rendered. The building became a hazard because the tenants used the equipment such as fire extinguishers hoses to draw water from domestic use. The tenants also made illegal connections to the transformer to obtain electricity. The building was petitioned and flammable material to erect shacks and building petitions. The building became a crime-infested site. The witnesses testifying to the fact that there would be a gunshot fire in the building, bodies of people killed in the building, and people would run into the building to avoid any possible arrest after committing crimes. The tenants in the building would pile waste of combustible material all over the place. There were also drug peddlers, with evidence pointing to some of the drug lords making income of up to 50,000 per day. The integrity of the structure of the building was compromised when the building was vandalized before the fire by the removal of recycling for cache of steel reinforced material supporting the building structure, namely columns, pillars, and slabs. 20. The vandalization of the building extended to the tampering with and removing firefighting, sanitation, and potable water connections and installation installation materials, further compromising the safety of the building, which was also not designed for residential purposes. 20.2, and necessitated that the former resident obtain water from the firefighting installations for their domestic needs. The safety was compromised when the building emergency evacuation features in the form of passageways and doors were blocked through the creation of living spaces in between stairways, interfered with through the reduction of evacuation passages and the construction in the emergency passageways of steel butler gates to secure residents and their property. Paragraph 22. The safety features of the building were compromised, with exit doors being welded and therefore not operable as escape routes. Some of the stairwells in the building were used as rooms, as so were toilets which were converted into rooms to house some families. The last paragraph that we find reliance and comfort is paragraph 25 on the same page, Honorable Chair. The land use rights of the building were changed or converted without due process, producing the dire consequences that we address later. Simply put, the building was in contravention of many bylaws aimed at the safety of its occupants. The main submissions that we're making in that regard, and we are saying that that is the evidence that is before this Honorable Commission, and that is the evidence that is correctly captured with reference to the transcript. We are saying, Honorable Chair, that when making any finding of facts pertaining to the city's failure to implement and enforce the bylaws, the Commission must take into account the conduct that is properly documented of those that occupied the building, which led to the very same unfortunate death to have even been exacerbated due to this conduct. No matter what EMS or anyone could have done in their best endeavors, they were confronted with this reality. And the question must be posed. Could this have been done without the knowledge that building a shack inside a building, another building, it's illegal?
Had you enforced the bylaws, would that not have been avoided?
Yes. That's why, my lady, what we are saying is that when you are to make a finding of any direction of duty or of abdication of duty, or even what could have led to the cause of fire, one cannot do that without clearly having to scrutinize the conduct of the occupiers. The question of the bylaws, no one, Madam Chair, is entitled to act unlawfully. We can go to all the rights that are entrenched in the Constitution. We are the beneficiaries of those rights, having a corresponding obligation to respect the laws of our country. The mere fact that the building is vacant does not entitle anyone, to illegally go and occupy that building. The starting point is the conduct that must be sanctioned. Why would you believe that it's a lawful and a right thing to do to simply go and occupy? I might leave my house for 6 months. No one has the right, because there are no lights, to go inside that house, irrespective of whether it's occupied or not. Her Ladyship might leave your house for 12 months. That remains your property. The rule of law simply says to us we have to observe the law. And self-entitlement and self-help can never be consummated in the light of our Constitution.
On the facts of this case,
Yes.
what would have been self-entitlement on the conduct of the victims?
It would be those that knowingly occupied the building through illegal means.
How illegal? Because people were renting rooms
But they were renting rooms to who? To the people
to the
who...
landlord.
No, my lady. To the
That
peop-
is the evidence before me, Mr. Mukwena.
No, I
The
understand.
evidence before me is that people who were desperate for accommodation found reasons to believe that they were being rented rooms by people who owned the rooms.
No, my lady. My lady, I accept that that is part of evidence, but let's move a step backward. And that is also recorded and documented in the evidence, which was captured correctly by the evidence leaders to say, clearly, we had South Africans and also 143 undocumented people in that building. The illegality does not start merely by you entering the building. The illegality starts by you even having to enter the country, being entitled to do so under the legal parameters. That's
So
why we
I've got
start.
to go back to where you come from in having to evaluate the evidence before me.
You have to start with the conduct that clearly perpetrated the means of illegality. There can never be a suggestion that where the two indonors or two people claim to be the rightful people to collect the rent, one does not have to use your own mind to know that in fact what we are engaging in an illegal scheme. There's no way that Pure or somebody else could have actually been on that building.
On the evidence before me,
Yes.
what could have alerted the person who wanted to rent the rooms to know that that was an illegal act?
My lady, on the clear evidence of me, firstly knowing that I am entering that building, knowing myself to be the one that must actually escape the law from how I've entered the country. That's the first thing. And you would want a safe
We are
haven.
talking about foreign nationals. I'm talking general about people who are renting the rooms.
Equally so, my lady. The evidence that I've read seem to suggest that when the Amaxhosa, ultimately took over the building, there was clear suggestions and evidence that initially that building was meant for, to be used
Yes.
by the pastor. Remember, it
Yes.
was meant to be used by the pastor. There was that transition that followed through violence and illegalities that made the people whom they know were not even supposed to be in that building taking over the control. The people that were receiving the very same rentals are the people whom they know that
Yes.
they themselves illegally occupied
Yes,
that building.
but the situation of people who invaded the building
Yes.
from Emaxhoseni is distinct from the people who were renting the rooms from the so-called landlords.
My lady, I might.
The people who invaded the building from Emaxhoseni
Yes.
were not paying rent.
Yes, my lady, we might be on cross purposes in terms of
Yes,
evidence, but
I'm sure we
I
are.
will find the relevant passages. Allow me to find because it could have not been that those people were distinct from a group that illegally ultimately hijacked the building and posed themselves as the owners to the knowledge of those that were paying the rentals. But I will find the relevant. I remember that
Yes.
I've read that. It's not, and it is not without knowledge of what was occurring in that building and those illegalities that followed in terms of the illegal connection of electricity and how the building was converted. It was converted with the full knowledge of those that were in the building, knowing that whatever that's happening in that building constituted illegality. And that's as far as you can take the submission to say, when taking the whip to the different officials of the city and also interrogating and analyzing their conduct in the failures that maybe they could have not actually followed or implemented the bylaws, one cannot do that in isolation of clear illegalities. I'll find the references which I want to tie up the time period. And those submission that you are making, Chair, is that there must be that proper weighing out of facts. One should not look only at the state organs and whoever else that might have actually tried to play a role in the situation or who might have actually failed to carry out their obligations. But it must be clearly on the premises of proper weighing those factors. And we are saying that that takes care of the first point that we wanted to highlight in that regard. The second
Okay.
point, Chair, pertains to the constitutional obligation of the city and its entities to provide services. This is a question that was quite difficult for one to navigate through, more so if some of the judgment relied upon, we appear to be extracting certain paragraphs of the paragraph of the judgment and without interrogating the facts of that case. For instance, the case of Grootboom, we know that it did not involve what we are talking about in terms of the people that were sought to be given the houses. It's quite distinct in facts in many respects, but we leave it at there. But secondly, the questions that occupied our minds are four. The first one was the question which was that what is the scope, the content, and the ambit of that constitutional obligation in the circumstances where there is evidence demonstrating illegality of connections of services and where efforts were done to disconnect, and nonetheless where there were threats of anyone that wanted to enforce in that regard not to be permitted to do that. Does that constitutional obligation extend irregardless? The second one, in the circumstances of this matter, where services were obtained, clearly so, through self-help, and on a number of occasions whereby there was interventions and those interventions were met with serious objections, where does one draw a balance of that constitutional right? And the third one is that can one extend that constitutional obligation in those circumstances that we have already highlighted and where there was clear non-payment of the services? Are we treating those that are engaging in illegal conduct much more better than ordinary citizens or even those that visit our shores coming from the other countries who would know that for any services that one must receive from the state, there is a corresponding obligation? Or are we simply saying that such an obligation from the state arises regardless of the circumstances and the facts? People can simply resort to illegality in order to jump the queue and obtain houses when as they know that that will be a much more effective way to jump the queue when you have citizens that might have actually waited for 5 or 10 years, properly so, waiting for housing from the government. Those are the difficult questions that were occupying our mind. But a clearest answer to that is that it cannot be in a constitutional state and where there is a rule of law that one cannot look at our conduct when we want to obtain certain services. And we have referred to quite a number of decisions which also interrogate not only the obligations of the state, but also interrogate and discourages any self-help from those that might be needy of those services. We are saying that there must be a weighing factor. We are not making the submissions, Chair, in order to defend any conduct which might be found to have been foul of not living to the standards expected of any officials. We are saying that any finding of fact that ought to be made must be made having to weigh all the circumstances. The last issue that you want to dwell with, it's simply in passing relates to some of the submissions, and maybe I must refer to them without, if I may refer to the Norton Rose submissions as the Honorable Commission refers to them. And simply echo our sentiments why we said that the finger pointing and the hyperventilations would not actually assist this commission, but what will assist this commission would be that meaningful engagement as to how can we join efforts in ensuring that this episode does not befall our country again. We do so with reference to the paragraph that was quoted on page 61, paragraph 129.1. Clearly, the questions that are posed there are not posed by the evidence leader without appreciating and understanding the evidence that was before this commission. And the evidence, that evidence is specific and it's relevant to the extent that we've made submissions about what was happening at Usindiso building. Correctly so, my learned friend, Mr. Sminya, says that the Usindiso building was a drug-infested platform run in part by foreign nationals. That does not come as a surprise, does it? The answer is it does not come as a surprise because continuous reports and even some arrests that are being affected by the SAPS confirms the issues of drugs and that there are drug lords and who they are, so it is not a surprise. Marlene, for instance, Sminya says, then the ringing question must be, how do we in future manage these concerns of undocumented migrants who come to our country? Mr. Matsaung says it is true. It is a concern. It needs to be addressed. We are simply adding to the submissions that we have made to say that one should look at the entire picture. These were not simply thumbsucked by my learned colleague, Mr. Splinya, but they were premised on the evidence that also traveled us from time to time. And we submit that any suggestion that such a questioning could have actually as xenophobic traces, it is indeed regrettable. This was premised on the evidence as was properly coached and outlined through the evidence of many witnesses. Chair, those then are our submissions on behalf of the city.
Thank you, Mr. Mukwena. We'll take a lunch adjournment and reconvene at 2:15. Advocate Semenya.
Chair, thank you very much. Perhaps before I deal with the submissions that the evidence leaders are going to make in our oral address, I need to sound my deep umbrage at what I consider to be ad hominem, personal, egregious attack on my integrity by Norton Rose. And might I invite, Chair, that we look at what they say on page 61 of their submissions. On page 61, if we are all there, so says Norton Rose. I think Mr. McQueen referred to this also in his address. Against paragraph 129.1, second paragraph on that page, says Norton Rose, foreign nationals have been cast as criminals and drug lords, impliedly responsible for the poor condition of the abandoned Usindiso building, and then they quote the questions I asked. There is nothing there that, as evidence leader, said the crime infestation in that building was by foreigners. Nowhere. And everybody should know by now that the fire was set alight by a South African, having killed another South African. So how could we make a claim under the heading, which you'll see the page before, xenophobia at the Commission? I think this is egregious. I think it's a personal affront on my integrity, and I have done nothing up to so far to isolate foreign nationals for anything. I have always consistently said to witnesses who confirmed that the building was under siege by criminals. Nowhere do I say that it is by foreign nationals. But it doesn't stop there. I want to demonstrate how vile a language my learned colleagues have had in relation to the Commission. I have placed before you, Chair, Madam Commissioner, a letter dated 2 April 2024. This, you would recall, it's a letter that complains about the fact that there is no opportunity given to the representatives to make oral submissions. But, Chair, you would recall that we came to that difficult conclusion that the terms of reference don't permit us to go into April. I came back and announced that we can't go into April, make your argument. There may very well be a way in which today happens, and it is happening. But let me isolate what on this letter they say at paragraph 7. They say, as the representatives of the victims of a disaster, we are appalled at the Commission's complete lack of regard for the significance of closing argument for the victims. Who speaks like that? Appalled? Seriously? It doesn't even stop there, especially in the face of our express intention to do so. Paragraph 8. In addition to the above, we are also shocked at the discourteousness of the Commission in failing to inform us about this sudden change of plans. Who speaks like that to a commissioner presided over by a past justice of the Constitutional Court? And with respect to Madam Commissioner Mabena, who speaks like this? It is contemptuous, and I want to put that on record. We have tried to extend our utmost courtesy to our colleagues. We have done so in one-to-one personation. We have done it in our writing. We have acknowledged gratitude to the extent that they were of assistance to the Commission. Never any discourtesy. Well, maybe let me get to the submissions, Chair. One, we do not propose repeating what we say in our written submissions. Chair, Madam Commissioner, you would have recognized that there is no full breadth challenge to any of the factual findings that we think are appropriate to make in relation to the evidence that was tendered. We described the history of the proceedings in their introduction, and there doesn't seem to be any particular offense taken about the mischaracterization of any kind of the evidence. So we are safe to say we have summarized the evidence properly. It squares with what the evidence was, and further that no challenge has been taken to them. So there is no point in us speaking much beyond what we say are our written submissions. We have thought that there are recommendations that can be made, and as we listen to the argument this morning, it would seem that by and large, SERI appears to agree, and where they don't, they qualify their agreement. But there are few that I will point, maybe not few, some which I will point to where they disagree. And in this regard, Chair, Madam Commissioner, we must make the point that there are no bright lights that are shown in the terms of reference between Part 1 and Part 2, which is one of the distinctions which are sought to be made. Yeah, this you make a recommendation about, but it properly belongs to Part 2. Well, I can't imagine anything germane to Part 2 that would not affect Usindiso building. So the lines are not that clear. That which applies in Part 2 must, per se, apply to Part 1. And that's why we're making the factual findings and the recommendations that we do. So that qualification is with respect not on its own feet standing. Of course, we are going to go to Part 2, and of course, we are going to repeat, at least in relations to the Usindiso type-like buildings, the same recommendations, the same factual findings. Okay. So says SERI, this building must not be demolished because, as they say, there is evidence or might be evidence relevant into a contemplated civil action and or criminal steps to be taken. But if that investigation is proper and they can do it, why are they waiting for the commission? Which brings me again to something that I keep repeating. This is an investigative body. An investigative body does not have an onus. It does not have a standard threshold of evidence. It does not have to find prima facie anything. The civil courts which will entertain the contemplated actions by the various victims will indeed consider questions of onus. It will indeed consider questions of prima facie proof of any of the claims. This commission did not go there. Compensation. We did not go there because we don't have the facts. Somebody says, I lost a TV, it was worth 10,000 rand. How do we know that to be correct? Even if we had jurisdiction to inquire into compensation? No, Chair. The submission we are making is that this commission's terms of reference are discrete and are distinct. It would be improper for us to indirectly take an approach regarding to what could be a civil action contemplated by the victims. It would also be incorrect on the face of what we have to be building up a prima facie case of criminal prosecution of anyone. We make the point in our submissions. We don't have sufficient time to drill down into individual culpability and or individual responsibility and or individual accountability. No, we don't. Where we do, for instance, with JPC, is because we have those facts. We have that evidence. We have engaged the witness about it, and she elected to say, I have no response to make. So we can correctly say, on the face of the evidence as you accept to be correct, we must be right then to make a recommendation that the board, in the face of an admission that there was non-compliance with the duties of an owner in respect of this Usindiso, must look into your conduct and take the necessary appropriate steps to deal with it. Whether they do or they don't as a recommendation, well, it's a different issue, but you can competently make that recommendation. Relating to the position taken by MNS, again, approbate and reprobate, confess and avoid is what I understood Ntate Mokoena to do. Says, yes, I recognize the fact that we may be responsible for policing the bylaws. Yes, we didn't, but weigh the two up and see whether or not there's no contributory, in inverted commas, negligence on the part of the residents. Well, that should suggest to us that we don't have to say much in relation to the contraventions they seem to be admitted. Was there a role by the tenants in the conflagration that became Usindiso? Of course there is. Should they take responsibility? I don't think we have evidence to put liability and or responsibility on any individual tenant. We don't have that evidence. We haven't gone that far. We couldn't in the time we have to go that far. But surely the waste that was there, the partitioning that happened, the material that was used as accelerants to this fire can't be ignored. And yes, Ntate Mokoena, you're right. There shouldn't be a consequence that says they are free of blame, but neither can the city. And the recommendations we are making is that, yes, we are able to point to entities whose responsibility they failed to discharge as required by law, national as well as the city bylaws themselves. So there is no challenge about that at all. Let me make the point about, oh yes, maybe I did, about whether the building should or should not be demolished. One again, I want to pose and posit a criticism that I think, together with the acknowledgement of praise by Norton Rose and a whole host of people who did pro bono work, we did engage the parties to say, please tell us, is there anything that we are doing which you think is wrong either, or that which we are not doing that you think the terms of reference require us to do. Nobody came complaining and said, yeah, but you did not call this witness on this topic. Even the question of compensation, I don't understand. If that was within their purview, come and say with your witnesses what case must be made for compensation. Just transposing that type of submissions on a conclusion by way of argument is not enough. This commission is unable to make any findings or recommendations that are devoid of the basis, evidentiary basis, for which those findings and or recommendations can arise. And I'm making this to say, if we're going to, now that we are going to part 2, please, give us the evidence upon which you want to place reliance. It can't be the duty of the evidence leaders. And I was making the point a little earlier that there are no parties before this commission. There is no burden on the evidence leaders to do anything which is not a burden on all of us. We are an investigative body. We are an inquisitorial body. We relax the rules of evidence, so everyone must throw their head into it. But no, SERI absolves all its clients. That can't be correct. They had the evidence. They want to put the blame on everybody, and correctly when they do, but you can't exculpate your own clients. You must be saying, as Mr. Ndatemukwena is saying, you must be saying to those who are occupying similar buildings, connecting wires illegally and taking water from the fire hose is not right. And building partitions in the building is not right. Waste, putting it there, accelerates the problem. Why is that not a proper conversation to have as SERI and their clients, as MNS and their clients? No, Chair. As I conclude, there is nothing we say in our written submissions with which I think full attack is taken. If I might just consult. Oh, yeah. I thought to refer also to what SERI tells us, we're remiss in buckling down to the resistance put up by residents at the expense of law enforcement. That's our paragraph 175. And we heard today, which again is incorrect, there can't be an attitude by a lawmaker whose responsibility it is to protect the interests of its inhabitants, to say no, a building got hijacked and therefore I couldn't enforce the law. No, that's not true. Any reading of our constitution, any reading of our constitution will tell us that those who have the obligations under the constitution must perform them. So in the face of the law, there is nothing called hijack anything. If your evidence was that it was illegal connections. Electricity that we know is when the officials attempted to clamp down on that, they were threatened and their lives were threatened, and they stopped. Not that it gives them a out of jail ticket. They still had a duty as a government to make good, to avoid the harm that happened ultimately to 76.
To thank all the legal representatives for their hard work in making sure that they participate in the proceedings of this commission.